Democratic Alliance's legal representative in the Public Protector's suspension court case has echoed President Cyril Ramaphosa's sentiment that there's no conflict of interest on his part. Advocate Busisiwe Mkhwebane is in court challenging the decision to suspend her, arguing that it's unconstitutional. Our reporter Athi Mtongana is live for us outside the High Court in Cape Town. Athi, tell us about the DA's involvement in the case and why it agrees with the president.
Advocate Butling immediately started out, Timbekile, by outlining and making it clear to the court that it's the Democratic Alliance that actually filed a motion against Advocate Busisiwe Mkhwebane, and that is why they are also part of these court proceedings. Now, one of the bone of contentions here that has been actually argued quite a lot is the chronological order of the events leading up to the suspension of Advocate Busisiwe Mkhwebane, which Advocate Dalim yesterday was arguing that the parties involved somehow have different dates insofar as when the actual Section 194 hearings started in Parliament. And so I'd like us to listen to what the DA's view is insofar as when these proceedings started, because now what they are saying is the issue now is with the wording, whether the committee had conducted meetings or whether they actually had witnesses to provide evidence before them, but they are maintaining that the starting of the proceedings actually gave way then for the president to actually even consider suspending the public protector from office. Let's listen to Advocate Butlinda.
On the 22nd of March, and that's not in your timetable, I have finally found a flaw in Advocate Bradenbach's chronology, but on the 22nd of March, if you could add it at the top, on the 22nd of March, there is a letter written by the Public Protector's attorney to the President. The reference is Bundle A, Volume 2, page 262. And it's a letter which says, please don't, I'm summarizing, please don't do anything about suspension. You are conflicted, and I'm bringing an urgent application, and I don't want you to do anything until that urgent application is over. There is correspondence back. I should have said that 17 of March letter said Advocate Mkhwebane had until the 31st of March to make her submissions. So she gets given until the 30th. So you can't take a decision before the 31st of March. But then the 22nd of March comes this letter, and then on the 31st of March, the very day on which the submissions are due to come in, instead Advocate Mkhwebane launches Part A of these proceedings. So we've got Part A of these proceedings which are launched.
Advocate Butlinda went as far as to argue around the issue of the delay of the suspension of the public protector from office, saying that in fact it was 14 days, 14 calendar days, as opposed to the year, as per the argument of Advocate Dalim. So let's listen to what he had to say.
Eventually, on the 26th of May 2022, and that's not in your timetable either, but on the 26th of May 2022, you'll see that the Advocate Mkhwebane makes her submissions to the President about suspension. So, has there been any delay up to that point? Well, obviously not, because remember, just to retrace the steps, there was the letter from the Speaker to the President on the 10th of March saying, we've started again. 7 days later, the President calls for submissions. And those submissions are only made, for a variety of reasons, on the 26th of May. The President doesn't want to make a decision before the submissions are made, so it's only on the 26th of May. And ultimately, of course, as you will see over the page, on the 9th of June 2022, the President makes his decision suspended. So the delay, if there were one, is a delay from 26 May 2022 to 9 June 2022. That, by my count, is 14 calendar days. That's obviously not a delay. He had to consider the submissions. So this suggestion that there is a delay of a year, and that argument was advanced vociferously yesterday, is an argument that is utterly unword in the facts before you. And Advocate Mkhwebane must know that it's unword.
Athi, what do we expect when court resumes at 2 o'clock?
we're expecting to continue with the Democratic Alliance, Thembekile, which is actually so fired up. You can just see their legal counsel just really trying to put the point of misconduct on the side of the public protector, saying that 21 judges ruled against her parliamentary interdict to stop the parliamentary process from taking place, saying that what essentially these 3 justices are looking at is to review the decision of 21 judges that have ruled against the public protector. Another interesting development is when Advocate Butlender put it to the 3 justices that in as much as they're not siding with the president insofar as the Phala Farmgate saga, because they've been very critical of the president, they've even asked the Speaker of the National Assembly to form an ad hoc committee there to look into the Phala Farm issue. They're saying that in as much as this is a serious matter, which they really are critical of when it comes to the president, but they are arguing that with reference to this particular case, this issue is not relevant, and that the issue of the Phala Farm issue is as serious as they have argued, but it is not relevant for these current proceedings, given the fact that they had not known what happened in Phala, and that the president had already indicated through communication not only with the National Assembly Speaker but with the public protector herself, asking her questions why he shouldn't suspend her. So she was of the view, that the public protector had been aware that there was this pending suspension hanging over her, and so the issue of the Phala Farm saga should not then be brought as relevance for the conflict of interest that Advocate Dalimpofu has been advancing in his arguments.
Mtongana, thank you very much for that. Athi reporting from Cape Town. Still